Big win for home buyers in Mumbai on Tuesday. The EOW arrested Jitendra Jain of Kamla Shri Builder and Kamla Landmark Constructions. These arrests were made in connection with Kamla's Santa Cruz project. The builder was charged with cheating, forgery and criminal conspiracy. Now on Wednesday, the developer, the bank, the civic body, the entire trinity was wrapped by the Mumbai High Court. The court was hearing arguments in two cases involving Kamla Landmark and Kamla Shri Construction. The High Court was especially harsh on the company, noting that all directors were involved in cheating buyers. The court also declared that if required, it will not hesitate to arrest the entire family. This is a big story with which we are kicking off on Property Hotline today, where we are exclusively focusing on project delays. So if you have any questions on what to do, if you are unfortunately stuck in a project where possession has been delayed, pick up that phone, call us now. In the studio with me is Uday Wavikar. Uday is the VP of the Consumer Court and Bar Association, Maharashtra and Goa, and he has been fighting for home buyers' rights for a long time. Uday, welcome to the show.
Thank you.
And I believe the court was very harsh on the developers today.
Yes, it was very harsh, and Honorable Justice Katawala is known for taking care of the justice as well as equity. And this was something where even the court really said that it may be a time when the entire family will have to be arrested for abetment and contribution.
And a case like this, Uday, should come as a big boost for all those buyers who have been fighting for justice.
I am totally with you. This is one of the landmark judgment. The builder's name is Kamla Landmark, but for them, for the home buyers, it's one of the most landmark judgment, where not only that the builder has been arrested, not only that the entire family cheating would be put, High Court has indicated, not only the directors are under a big wrath of High Court, not only that, but even a civic body like Mumbai Municipal Corporation is also under wrath.
Right,
so what is happening
so essentially the court has pulled up everybody and hearing is still underway in the case. Not just this, the court has fast-tracked hearing in all cases involving Kamla Landmark, and that is something that we'll continue to track. But let's get started with our questions that have come in on Property Hotline. We have Abhishek who sent in a question on email from Noida. Now he says that he's bought a 1 BHK flat at Aman 3 by JP Infratech. He bought this in April 2012, Uday, and he paid 9 lakh then as advance amount. The cost of the apartment is 21 lakh rupees, but the project has not yet started. We are in 2016. Abhishek visited the office. There was no response. What should he do now?
He has two options now. One option is that he can file a complaint before the Consumer Court, because 21 lakhs he would come, and if the project is in Mumbai, then he would come before the Maharashtra State Commission, and that will be very good for him, because there are various judgments of Consumer Court of Maharashtra.
Oh, this is a Delhi project.
Then he'll have to be at the Delhi State Commission, which is at Delhi, and then Delhi also has given progressive judgments, including alternate flat or market value proportionate. So this is what consumer courts have so far really given wonderful judgments, including the compensation cost for mental harassment and agonies and legal costs. So he can definitely file, because if the agreement says that he was to get, normally the possession has to be given in two years, and on the date of agreement, if the possession is not given to him, there is a state deficiency of service, also unfair trade practice of utilizing his money so far by the builder as his project investment. And if he is also having rent, that is another consumer court can give him a relief. If he is paying the rent, he can get an interim order that till such time he doesn't get the flat, the rent will have to be borne by builder. Like Bombay High Court.
So hold on. Uday, what you're saying is he can go to court and he can actually ask the court to direct the developer to give him an alternate flat or the market value. And by market value, that is the current market value of the flat that he had booked in 2012. The other thing that Uday is telling that you can ask for is for rent. If you choose to go ahead with the agreement, stay in the project, if you choose not to exit, in that case, you can ask the developer to continue paying rent.
Not only go ahead,
you get possession,
Kavita,
right?
Not only go ahead, if he was paying the rent for the delayed period, say for example in this case, he is booked in 2012. Right. The builder has promised, say as per his agreement in 2014. the flat is not complete, we are in 2016. From the promise date of 2014 till the date he gets the possession, if he is paying the rent and if he has the proper rent agreement and receipt, as an interim relief, Antarim Adesh is known as interim relief, he can claim the rent, whatever rent he has paid for the delayed period, as well as for the future till such time the flat possession along with occupation certificate and completion certificate is given to him.
But for all of this, what you do need to remember is that ideally you should have an agreement. Ideally, you should have registered that agreement. Now, that is the first and the most important thing that you need to do once you complete the procedure of buying the house. We have a question that's coming from SAR Reddy now from Vishakhapatnam. Reddy booked a 2 BHK apartment in Samarpit project in the Hebbal area in Bengaluru with the builder Dreams Infra Private Limited. Now, he's paid 30% as down payment in a pre-launch offer in October 2014. He also got an MOU from the builder saying that a separate agreement will follow and the MOU is valid for 24 months. Now, 24 months is over, the builder has not started the project, but Reddy was told that the project will start within a few months. 18 months have passed by since then, but there is no response. He's already paid 7.9 lakh rupees and obviously is now worried about seeing his money. He wants to know what he can do, whom to approach and how to cancel the agreement and get a refund of the money he's paid. Now, again over
Kavita,
here,
has he got a registered agreement because he says there's an MOU. Now, if it is a MOU, he can, of course, either way he can go to the Consumer Protection Act, there is no question about it. Not only he can get the agreement, get a direction, if he is not entered an agreement, only MOU is there, then get a direction from the court that agreement be entered with him if he chooses to continue with the project, and also ask for compensation for delayed period as and when the flat will be given to him, or so far or he can ask the alternate flat in the same locality at the same rate, which is...
Now, Uday, here, the case here is there is an MOU. There is no agreement that he signed.
But
now,
as far as Consumer Protection Act is concerned, an MOU would also be concluded contract.
Okay. So, if he chooses to exit, which is what he is also saying, that if he chooses to exit, out of the
then he can get out by he can get a refund with interest. Now, what we normally do in Consumer Act is, suppose the builder is taking for defaulted amount 22% interest or 24% interest, if it is there in the MOU clause, he can also claim same interest, his own amount, which is his deposit.
The buyer can claim that the same interest.
Because the same equity would be on him. Because if I default, you are charging 20 to 24%.
And this is the case even if it is not a part of the agreement.
Correct.
The buyer's
yes. This is what we are going to pray in our prayer of Consumer Protection Act, because the justice demands that equity should be on both sides.
And in fact, this is something that has already been enshrined in the rules for RERA as well.
True.
So, it's a matter of due course when it will actually be implemented across the country. But you can still go to court and demand that you be treated on par with the developer. So, if the developer has a clause in the agreement saying that you have to pay 22% interest on delay, then you can also demand for 22% interest if the possession of your project is delayed.
Along with mental harassment, agonist cost and the legal cost.
Right. We have Sandeep now who's called in from Jamshedpur. Sandeep, how can we help you?
Yeah, good evening. Nice talking to you. And thank you very much, Mr. Uday, for advising us. I have taken a property. I had booked this property in the year 2008. And thereafter, the builder...
Where is this property?
This is in Jamshedpur, by the way.
Okay.
Yes, this is in Jamshedpur. So they have promised within 24 months. But they didn't do it within 24 months. But we went on paying as per the schedule. As per the schedule, like, first slab you pay 5%, 10% like that. We completed almost 80%. But till today, the property is not complete and the infrastructure is totally zero there. There was it's a 9-floor building. They were supposed to give us 2 lifts. They have only given us a small lift, which half a day does not work or sometimes work. We are all senior citizens, so we are really in a problem. More so, in a high-rise, there is no, electricity those electric arresters. No, all the other statutories which are supposed to have in a in this building, these are all not there.
So Sandeep, essentially what you're saying is the structure is more or less ready, but all the amenities are have not been given, and the utilities, your water, electricity, sewage, etc. is not there.
Are you in possession?
Have you got possession?
Yes.
Okay.
Now what we did is, because he was delaying and we were paying the loan amount and heavy interest was there, so we asked the builder whether I can complete my flat and get in. So he said, okay, you go ahead with it. So we did that, and we got a possession letter also, and we have moved in. But now moving in, we find that with all those things, electric arresters, everything not there, and if there is an emergency, we do not know what will happen to us. So, and I have in records repeated reminders to that builder telling that when are you going to do, and you will be liable for any loss.
Right, Sandeep, right. Let me get Uday in. You know, Uday, this is what this is what keeps happening, because a lot of times we have experts counseling people that you can, if the structure is ready and if there is very little work that needs to be done, you all can just pool in money and finish it. Now in Sandeep's case, they have actually gone ahead and done it. And but despite that, the basic facilities which the developer should actually contractually give them, the utilities, electricity, water, sewage, those are not in place yet. What can buyers do then? Because now that the building is complete, the developers wash his hands off the entire thing.
No, you can't wash off the hand like that. In fact, the best fast-track court, as I always say, he can go to a civil court for civil damages or file to the respective high court, and maybe Honorable Justice, just like Honorable Justice Katawala may act fast. But the fastest track that he has got, where he can get interim reliefs also, is the Consumer Court at Jamshedpur. Why Consumer Court at Jamshedpur is because he has taken already the possession. So the price of the flat will not be calculated. He is going to ask only the amenities, and he is also going to ask the essential amenities like lift, water charges, plus he is going to ask for occupation certificate if it is not there, if a building completion certificate. So he is going to ask formation of the society and the conveyance to the said society. So all this he can ask before a Consumer Protection Act. He can go for interim relief of the water supply. But what you have to do is, you have to invite an architect, preferably on a panel of Consumer Court, otherwise any other architect who is on the government panel, recognized architect. Get the photographs of the building, get the reports of the amenities not done, get the value, what has not been complied, the formalities with the municipal corporation or the local authority, and then get a valuation for that also. Suppose you have to do that, what would be the expenses? And you can claim all that and go for an interim relief, saying that this must be immediately given. Water supply not proper, you can go for an interim relief. If you have other logistics which are absolutely essential, including occupation certificate, you can go for interim relief. So this is the way you can proceed in a Consumer Court. Consumer Court also takes 3 to 4 years, but the justice is fast, and many builders have gone to the jail through Consumer Courts for an execution in Consumer Court.
Right. Uday, also in Sandeep's case, now they have taken it upon themselves over here to complete whatever construction was there in the building. Now I'm assuming that Sandeep has maintained accounts of whatever expenses he's undertaken to complete the construction. And if that is the case, can they also claim compensation for these expenses?
100%. What Sandeep has to do is, as you rightly put, for completion of his flat, whatever he has spent, the contractor's bills, the other bills, and a consolidated bill of contractor of all other bills, he has to take, and one affidavit of contractor will have to be taken, which can be drafted. He can take the assistance of a good lawyer locally, and this can be drafted so that there is enough evidence of what he has actually spent from his pocket, which builder ought to have spent as per the amenities in the agreement.
Right, Sandeep. So here are the friends that you need to make immediately. You need to make friends with an architect and a lawyer. Get both of them on your side. And ideally, it should be a government empaneled architect who will tell you what are the facilities that are missing over here, what are the amenities that are missing, which the developer is duty bound to give you, is bound by contract to give you. Now, once you get a clarity on that, you also need to get a contractor's affidavit saying that you've spent so much money. You can actually go to court and you can ask for reimbursement of all the expenses that you have undertaken to finish construction on the building. And secondly, you can ask the court to ensure that the developer provide you all the facilities, the amenities that he is contractually bound to give you. We have Rakesh who's called in from Noida. Rakesh, what is your question?
Hello, good evening, sir.
Good evening.
My question is, sir, I have taken a purchase of flat in the Lotus Inn apartment on Noida, Greater Noida Expressway, and the project is delayed by more than 1 year. And you see, as you have mentioned, and I was seeing your program yesterday also, so you have given that the remedies available, we can go to consumer court or other courts available.
Yes.
But my question is that most of the builder-buyer agreement, or I think in 99% cases, it is totally skewed in favor of the builder.
Correct.
Because the builder made the terms and conditions in such a way that nobody can claim the delayed penalty, basically. Penalty because of the delayed. So in that case, what are the remedies available to the buyers, sir?
See,
like they made that.
Yes, please go ahead.
Yeah, like they made terms and conditions that if you, when all the payments will be made, 100% of the payments will, then only you are liable to get the penalties. Secondly, when all the payments are made without any delay, then only you are liable to get the penalties payment.
Rakesh, all of this is there in your contract?
Yeah. These are the standard contracts, and even I have taken this property on loan, and the last 2 years I have been just paying the interest, and I am losing on the interest amount because the possession has not been given, so I cannot claim the tax benefit also. And the loan amount is also very heavy, 60 lakhs loan amount is there. So in that case, what kind of remedy is available to us?
Can a tilted agreement, what we've been regularly discussing on the show, can a tilted contract actually jeopardize your chances of getting a good
unfair
judgment?
Terms of agreement, one-sided, unilaterally, arbitrarily dominating agreement, having a monopolistic attitude with an exploitation of a consumer. And fortunately, our Supreme Court as well as the Honorable High Court of Delhi in DLF case, DLF Bangalore's case, and then the High Court Bangalore and the Karnataka, and then the Supreme Court. The DLF has been charged crores of rupees penalty through an competition commission for the purpose of this kind of unilateral terms. And that is one of the, not only DLF but Unitech is also charged like this. So there are several precedents where the shortest cut, as I always say, is he can go before a consumer court for unfair trade practice and this kind of one-sided agreement and challenge the agreement terms itself. He can definitely get the interest compensation, not only interest and compensation, but he can also get if he is taken a rent. Now here the problem is the thing is ready. So expedited order with occupation certificate to give a possession within a stipulated time-bound program he can claim for. Alternatively, he can claim for any other flat in a ready possession also if that is not possible to be constructed, or a proportionate market value of what he has paid along with proper compensation. So this is what he can claim, and for the agreement will not be binding on you. If it is unilateral and arbitrary, as you are saying, there is a Pushpendra Cooperative Housing Society judgment of National Commission of Consumer Court which says that these agreements are not, terms of the agreements are not enforceable because they are ab initio void against the law, against the public policy, and such agreements are called as unconscionable agreements in Contract Act. What is an unconscionable agreement is, if I give you a loan in 3 months, you don't return, I'll cut your hands. So these are unconscionable
Rakesh, essentially what you need to understand here is that the basic, like you said, the tilted agreement that you've signed, just by signing that itself, you've already been done an injustice over here, which itself is grounds enough for you to go to court. And now you've not been given possession of the project as promised. You have enough grounds to go to court, and that should really not hold you back from seeking justice. We have Hani Narwani who sent in a question from Mumbai now. Hani says that he got a flat in Virar West 3 years back. Now the agreement has been registered. According to the registered agreement, the date of possession is 31st December 2016. But when Hani visited the site lately, there were no signs of possession. I think he means construction here. And the person sitting at the site told Hani that possession would be delayed by another 3 to 6 months. Now Hani wants to know whether he can claim interest if he didn't get possession on time as mentioned in the agreement. If yes, what is the legal process to follow for claiming it? Also, according to the law, till when does he have to give till when does a builder have to give him interest? Is it till OC, possession, or till fit out? You know, what I find interesting is the way Hani's actually gone and checked on the project just in time for possession. He already knows that there is a delay, the project is not going to be delivered on time, And that's in fact how proactive you need to be if you buy a house, right, Uday?
We must compliment Ani for the homework that he has done, and I appreciate his concern as well as the alertness that he has shown. I feel, Kavita, there is now a judgment, my judgment, though it is before now Supreme Court, but there is no stay so far. The question is against Lodha builders. So, there again the similar question was there that the builder charged unnecessarily extra amount, did not give the flat in time, and therefore a compensation for 85 lakh amount that was paid by my client. His name is Elmer De Silva, and Magicbricks did a show on this also. Got 51 lakh compensation total. So,
right.
The point that Ani was asking, let me be very specific to him, that when he asked the compensation before Consumer Court, either at National Commission or State Commission, depending on the price of the flat that he has, because if it is above 1 crore, he has to go to National Commission, or he can go for civil damages also in a civil court, which may take time, but if he moves out High Court, it may be faster, like we have one case here, depending on the what you choose to do it. But consumer courts have very heavily come forward.
You know, Uday, you just brought up that fact about how if the value of the flat is above 1 crore, you need to go to the National Consumer Redressal Forum, which is based out of Delhi. Could you just break it down for us on the basis of, value of the flat?
If your value of the flat is, and if the possession is not given, the main thing is if you have not taken the possession. Because if you have taken the possession, then the value of flat, because you are not asking for the flat. What possession? What you are asking is then the statutory rights. So, basically, if the possession is not given to you and you are asking for possession, then you have up to 20 lakh, you have to go to a district forum. From 20 lakh to 1 crore, you are there to the State Commission of Consumer Court. From 20 lakh and that is from 20 lakh to 1 crore. And from 1 crore above, you have to go to National Commission.
So that essentially is the breakup for you, and this is how you can decide which court to go to. But remember, this is if you have not taken possession.
Correct.
Of the flat. Correct. Now, a lot of times, Uday, developers say you take possession or you take fit out in a delayed project. Take the fit out, take the possession. The rest of it will come. We will give you the rest of the amenities. True. We'll give you, like we saw in an earlier case, in an earlier question that we discussed. What happens then? Where do you go?
There is a debate today, even in courts. The debate or the proposition is that can you take the possession without occupation certificate? The local authority rules, including the municipal corporation, says you can't take. Maharashtra Flat Ownership Act in Maharashtra says it is illegal to take a possession without building completion certificate, and the person who gives the possession shall not give and who takes the possession shall not take, and this is section 3 of MOFA. Now what happens is, under the consumer code the criteria is slightly different. Consumer court says that flat is a commodity, and mostly the so far judgments are supporting this logic. There are few other judgments also, but depending on circumstances, the logic is that you have paid entire amount to the builder of the flat, or you are paying from time to time. If he has delayed the construction, whose fault it is? Whose responsibility is to get the occupation certificate? So therefore, a flat has been considered as goods, and if I give you faulty or defaulted goods like the flat with encumbrances where you can't stay without the permissions, then it is a deficiency of service. Therefore, consumer courts are not very heavy if you have taken the possession. On the contrary, they feel that the builder has defaulted, and there are several judgments. Even after 10 years not taking the OC in Mumbai, the cooperative societies builders have been charged the penalties. So therefore, you have an option of consumer court. Civil court might think that you have, both the sides have done illegal thing, you have taken a possession.
Right. Also, very quickly, he asks, according to law, till when is the developer supposed to give me interest? Is it till OC, till possession, or fit out?
I was coming to that. The interest is supposed to be given to you till possession, but not the physical possession or fit out possession till the occupation certificate. I would go one step further. You can ask for building completion certificate.
Right.
Because most of the cases, the building completion comes first in outside metropolitan cities, but in metropolitan cities, they give occupation first and then building completion.
So from the date that you were promised possession, till the date that you actually receive the possession, and that is after the completion certificate
and the occupation certificate.
And the occupation certificate is in the hand of the housing society. You can actually claim interest for that entire period. We have an email from Somnath, who's from Mumbai. He says he has invested his hard-earned money in an apartment with the hope that it will get completed in time. Uday, we just keep getting these questions. He says either he will reside in that or he may sell it, depending upon the circumstances, as there is no hope for the project to get completed. His money is blocked here. He's finding it tough to sustain his everyday life. He alleges that the builders do not listen at all, and that if you fight by not paying the money, then they put all kinds of delay charges to harass them further. What can he do?
I totally agree with my learned friend, and not only sympathize with him, but it's a burning issue today with most of the builders, because they do not have finances. And with this now our Prime Minister's operation, I feel that there will be further delays, but that's a different issue. Now here he can do three things. Not only the consumer court, but here he can definitely go to consumer court and he can get the interest compensation. But I would suggest him to go, like our friends did it, to file a cheating case against him, a criminal case, because this is a cheating. If he has not maintained the schedules, and if he is not even, if he is asking further money, then it is definitely cheating. And he can go for cheating. Even he can go against, if he is in Maharashtra, violation of local authority rules like MOFA, GOFA or Hyderabad, which the act you have, where you have taken more money than required, more than 20% money at the agreement time, and then you have not completed the work. So criminal complaint can be filed, that can be followed up through. Simultaneously, you can file a civil damages case, or you can file a consumer court complaint. Consumer court always will be much faster and much beneficial to you. And you can ask for your possession in time-bound program, or alternatively you can ask for the refund at the proportionate market value if that is more, or you can ask the refund with 18% or 22% interest, because if the builder is taking, as we discussed, for defaulted cases 22%, you have every right to ask 22%. Generally the courts give 18%.
Right, so there are a whole host of things that you can actually demand, whole host of relief that you can actually demand from court if unfortunately you are stuck in a project where the possession has been delayed. But to do all that, you need to know your rights as a home buyer. And the first one is, of course, that you need to demand an agreement. You need to ensure that if you pay any money whatsoever to the developer, you sign an agreement, you register that agreement. And also you need to be a proactive home buyer. You need to keep visiting that site regularly, at least once a quarter, to ensure that there is some progress on the construction in the project. And of course, like we keep saying here, always ensure that you write to the developer and you get a written response that will stand in your stead in the court of law. With that, we come to the end of this special episode of Property Hotline. Uday Wavikar, thank you very much for coming in and answering all those questions. And of course, we will help you with answers to all of your questions related to real estate, whether it's buying, selling and investing, legal issues, home finance or taxes on real estate. Call, write in or personally tweet to me. I'll make sure that the experts answer all your questions. Thank you for watching Magicbricks Now.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/magicbricksnow. And don't forget to click the like button. You can also follow us on Twitter at magicbricksnow. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/magicbricksnow.